understanding that the defendant's going to waive formal presentation to grand jury today and agree to plead to the information as filed. It's misdemeanor of first degree theft, violation of 2913.02A3. If that's acceptable to the court, that's the state's understanding this morning, and I believe Ms. Titkemeier is willing to waive formal presentation to grand jury, but I'm sure you can inquire about that.
Yes, thank you, Mr. McElroy. So let's just start with the waiver, okay? If you guys could stand up. So, Ms. Titkemeier, first of all, there's a lot of steps in this one, okay? So what I have in front of me is a waiver of indictment, okay? You went over this with your attorney?
Yes, sir.
And you've signed this, correct? All right, Mr. McElroy has signed it as well, and I have now signed it. But what this means is you have a right. You have a right, if they wanted to charge you again, to have this presented to the grand jury. Then the grand jury would decide whether there was an indictment, and then it would come back to me, right? Because you're on probation to me. This says, you know what? My attorney, myself, Mr. Loisel, we've made this agreement. I know we've agreed to this plea, so I'm going to waive my right to indictment and just go ahead and do what we call, it's this bill of information, basically. Is that your understanding of what we're doing today?
Yes, ma'am.
All right. So, you've signed that, and the court is going to sign that, and the court does find that the defendant has knowingly, intelligently, and voluntarily waived her right to formally be indicted by the grand jury in this case. So, now we will turn to the actual charge, Mr. McElroy. And that is a misdemeanor of the first degree theft, correct?
That's correct. Yes.
All right, and you may go ahead and enter your plea.
Yes, on behalf of Ms. Titkemeier, I would acknowledge receipt of a copy of the bill of information. Waive any reading of the bill of information. I've had discussions with Ms. Titkemeier about, obviously for some time, about this case and this charge. On her behalf, I would enter a guilty plea to the charge as outlined.
Thank you.
Judge, if I may, the only
Yes, please.
The only other thing with respect to this is a misdemeanor of the first degree. Obviously, we're outside of the time frame with respect to statute of limitations, but I believe that's waived also by counsel with respect to accepting this bill of information because the activity with respect to this took place back in 2021.
Is that your understanding then, Mr. McElroy, Ms. Titkemeier, like usually you'd only have, the state would only have so long to present a misdemeanor, but you guys have worked something out. Again, you went through this plea, you're on my probation or community control already to me, and you've made the decision to go ahead and plead to this new misdemeanor, correct? Mr. McElroy?
That's correct.
Anything else, Mr. Loisel?
No, thank you, Judge.
All right, all right. And she's withdrawing her plea of not guilty at this time?
We never entered a
Oh, right, sorry, you're entering a plea of guilty at this
straight
time?
entering a guilty plea.
All right, thank you. So, we have a conversation with Ms. Titkemeier?
Of course.
So, Ms. Titkemeier, we're going to have the same conversation that we had before, a little bit shorter because it's a misdemeanor. Can I have you raise your right hand? You swear the testimony you're about to give will be the truth, the whole truth, so help you God? All right, you put your hand down. Just state your full name for the record.
Lisa Marie Titkemeier,
And how old are you?
39.
How far did you go in school?
Associates?
So read, write, understand the English language. Ever served in the military?
No, ma'am.
Are you a U.S. citizen?
Yes.
So I'll ask, have you ingested any medication, drugs, or alcohol
No.
that would keep you from understanding what we're doing today? Now, have you ever suffered from any mental illness or disease? Yes. Okay, so now let's talk about that. I know you're going through treatment right now because you're on my community control. Are you on any medications for anything at this point, or are you
Yes.
past that?
Yes,
You
ma'am.
are?
Yeah.
All right, now, do those medications at all get in the way of what we're doing today?
No, Your Honor.
All right, I'm gonna guess most of the time those medications probably make you feel a little more clear-headed than they do the opposite, right? All right, okay. Anybody threaten you to make this new plea?
No, Your Honor.
Did anybody promise you anything except for the discussions that you guys, your attorney had with the state of Ohio before you came to me?
No, Your Honor.
All right. Do you have any questions about what you're pleading to?
No.
All right. You satisfied again with Mr. McElroy's representation of you?
Yes, Your Honor.
Answered all your questions on this?
Yes.
I take it any other discovery or whatever was behind this particular charge you went through and weighed the pros and cons?
Yes, Your Honor.
And you understand now the allegation that's in this information guilty plea or once again making a complete admission to this new charge in the information.
Yes, sir.
Again, the maximum penalty in this case is a misdemeanor, is 180 days at the Correction Center of Northwest Ohio. Is that your understanding?
Yes, sir.
All right, that's 6 months, 180 days, right? Also, the court can fine you up to $1,000. Do you understand that?
Yes, sir.
All right. And again, when you take a plea, you're reducing your appellate rights. Basically, you can appeal if I mess up giving you your rights, or if I give you some kind of a legal sentence, you can appeal me. Do you understand that?
Yes, sir.
Now, you know that this is not mandatory, even the 180 days, so I can put you on probation for up to 5 years. All right? And you mess upon my probation, I could give you more restrictive sanctions. I could lift that stay of 180 days. Do you understand that?
Yes, sir.
All right. I could also make you do any other things. I could, you know, give you EM. I could add things. I could have you do more community service. There's tons of things I could do on top of that. Do you understand that?
Yes, sir.
All right. Let's talk constitutional rights again. And it can't
Judge, may I
accept your.
just a moment? I
Sorry,
apologize.
go ahead.
Thank you very much, Sean.
All right. Okay, so let's talk constitutional rights. Same thing we did before. I'll take a few at a time and ask if you understand. First off, you do have the right to a trial. Jury of 12 of your peers, you try the case to the court. They all have to agree, or I have to agree, the state has proven every element of this information beyond a reasonable doubt. You understand those rights?
Yes, sir.
Right to have Mr. McElroy, right to confront each person who testified against you, right to bring witnesses on your own behalf by the use of subpoena. Do you understand that?
Yes, sir.
Right? Finally, you can't be required to take that stand, but you have that right if you want to. If you don't want to, I give a jury instruction. I know myself, nobody can use that silence against you to decide whether you're guilty or innocent. Do you understand that?
Yes, sir.
All right, so do you understand all the rights as I've read them to you?
Yes, sir.
You know by entering a guilty plea, you're giving those up. Is that what you wish to do?
Yes, sir.
So I'll ask you, how do you plead to this misdemeanor today?
Guilty.
And are you doing this voluntarily?
Yes, sir.
Stipulation this occurred here in Lucas County, Ohio.
Yes, Your Honor.
You want to add anything, Mr. Loisel?
No, thank you.
All right, so I have in front of me 2 different sheets, Ms. Titkemeier. These are your plea forms, and I see your signature 3 times. Are those your signatures?
Yes, sir.
All right, you went over these with Mr. McElroy?
Yes, sir.
Similar, but not exactly the same as the ones that we had went through before, right? Everything we just asked you question and answer, same thing as these? Any questions about any of it?
No, Your Honor.
Right, the court does find that defendant has been informed of all her constitutional rights. She understands the nature of the charge, effects of the plea, as well as the penalties which could be imposed, has made a knowing, or voluntary, intelligent decision to enter a plea of guilty to the information as charged, count 1, misdemeanor theft, 2913-02A3, 2913-02B2, misdemeanor of the first degree. The court does accept that plea, does find her guilty of that offense. Before we go forward any further, can I have the parties approach? Sean, can you approach too? Yeah. Okay, so absolutely not. Absolutely not. She has to be walked over off the deputy. So that's their rules, not mine. Yeah, that's what I wanted to tell you about,
Thank you.
so give me a second. Thank you. So future reference in case we ever need to know.
Thank you, Judge.
All right, so it's my understanding though the parties would like to go forward with sentencing today, is that correct?
That's correct, Your Honor.
All right, Ms. Titkemeier, again, I just want to make sure you understand, you're still under oath. You have the right, I can get another pre-sentence investigation report, probably get an update, find out how you're doing on probation, although I haven't received any probation violations on you. They'd get a report on this new charge and tell me what their recommendations, or if there would be any further recommendations on this. Do you understand you have that right?
Yes, sir.
Your attorney though, and and says that you both wish to forego that and you'd like the court to sentence you today, is that correct?
Yes, sir.
All right. And state of Ohio has no objection, so I'm gonna turn to the state of Ohio with any statements or recommendations that they would like to make.
Judge, just for informational purposes, the activity included in this bill of information predates the activity that this court is aware of with respect to the felony that this defendant pled to late last year. That was taken into consideration with respect to this resolution. Additionally, the state would offer that Ms. Titkemeier did collect approximately $13,000 in relation to the Brandon Stalker Fund and turn that over to the foundation. During the investigation and post-investigation on the felony charge, additional money was found that was not turned over, and that's what is included in this particular case. With respect to the amount and the activity by this defendant, the court or the state talked with counsel, and that's why we are in a position to have a plea to a misdemeanor. Additionally, Judge, with respect to restitution, I spoke to counsel. That amount has already been included with the restitution of the felony case, so there's no additional money that needs to be made part of the record today.
Thank you. Mr. McElroy.
Mr. Loisel just said many of the things that I was going to tell the court, but I will add that the underlying conduct that is the subject of this matter, the court was aware of, the parties were aware of at the previous sentencing hearing. I believe the court even made reference to, and there's this other thing going on with the Stalker Fund. So much so, the parties were so aware of it that it ended up getting thrown into the restitution amount for the previous case. That said, Your Honor, if you look at as I know the court knows and must, look at the principles and purposes of misdemeanor sentencing, they're very similar to the principles and purposes of felony sentencing. We're looking to rehabilitate the offender, punish the offender, and provide any restitution that may be needed, and to protect the public. As the court is aware, the court ordered Ms. Titkemeier to do, I believe it was 200 hours of community service as part of her previous sentence. She not only did the 200 hours, she did 369 hours. I provided documentation to the court. Sorry, 359. Ms. Titkemeier corrected me. I threw in an extra 10. I apologize. I provided documentation that to both the court and the state. Additionally, she is now employed. I provided a letter from her employer to both the court and the state. It is apparent from that letter that her employer seems to think that whatever her indiscretions were previously, that many of the principles and purposes of sentencing have been achieved as a result of this court sentence, and Ms. Titkemeier is following those conditions, completing her volunteer work, so much so that she ended up getting a job offer from the very place she was volunteering. I think perhaps I highlighted the sentence that's in the fourth paragraph of the letter. It says, her story is a reminder that people can change and that second chances matter. And I think that's, I would hope that that in some way can guide this court in determining an appropriate sentence on this charge. Ms. Titkemeier has demonstrated she can abide by conditions imposed by the court, so much so that she goes above and beyond the conditions that are imposed by the court. She now has not only employment, but it seems fulfilling employment, fulfilling both for her and for her employer. So on behalf of Ms. Titkemeier, I would ask that the court consider a sentence of probation or community control such that she can continue on the path of rehabilitation that she has already started. I would hate to see, as I suspect the court would not like to see that interrupted or disrupted by any sentence. Rather, let the sentence continue and to Titkemeier has written something that she would like to read to the court. I have nothing further at this time.
Thank you. Ms. Titkemeier, go ahead.
Your Honor, just over a year ago, my life took a drastic turn. I entered a sentencing facing one charge only to learn about another charge related to the hot chocolate stand, which I was unaware of at the time, and there was no charge concerning it. In that moment, I felt though as I had lost everything and sorry.
That's all right. Well, it's,
Yeah.
if it ever
I'm
has to be
sorry.
transcribed, but, I mean, it is, we are recording it rather than.
I just want to make sure that the court can understand.
I'm sorry, Your Honor.
So
I talk fast, so I have no problem listening to fast, so
Okay.
it doesn't really bother me. Go ahead.
To this day, I'm sorry, I felt as though I had lost everything, was overwhelmed with confusion and emotions that I struggled to express. To this day, I carry immense remorse, which I know will be a part of my life forever. Hosting the hot chocolate stand for the Stalker family was a deeply meaningful experience, and we felt incredibly fortunate to raise over $10,000 for them in just 2 days. Over the past year, particularly the last 7 months, I have been granted a second chance at life. I have an amazing support system, including my workplace, which motivates me to become the best version of myself and to live with integrity. I have completed my 200 hours of community service, but didn't stop there. I have volunteered a total of 359 hours. This experience has allowed me to build relationships, discover my purpose, and truly feel at home. My volunteer work has been incredibly rewarding, fostering my growth and helping me transform my life into one guided by truth, honesty, and faith. I am grateful for the job I have now, which I earned through dedication, consistency, and perseverance. I attend multiple therapy sessions each week, meet regularly with my probation officer, and comply with all conditions of my community control. I am truly remorseful for my actions and the pain I have caused others. If I could change the past, I would do so in an instant. Thank you for allowing me the opportunity to share this with you today.
Thank you. Anything else, Ms. Titkemeier? All right, well, I mean, I think what this comes down to is I think, Ms. Titkemeier, you are well aware of the way that this court felt about your actions when I sentenced you the first time. I don't need to relive it because you know it and you heard it, and I actually think you listened to it. I saw how much community service you did. You know, there's a couple things though I do want to say that's interesting. First off, I know that, you know, a lot of what you just said, I mean, I think a lot of people could hear that and roll their eyes and say, well, sure, that's what you're saying. I hope that you understand that most of the people you hurt are probably never going to believe that you're rehabilitated, right?
Absolutely.
But I would say, I don't, know if you're totally rehabilitated, but I would say you're clearly well on your way. And the fact that you're still working for a place that could be considered community service in itself, I think is a great thing. And I hope that that's what you continue to do, is help the community. This case obviously had a lot of media attention because it shocked the senses. That's what we call it, right? But it's funny, if everybody had been here throughout my docket today, I would be sort of disingenuous to not acknowledge and give you another chance and not count this against you as something that previously happened, when so many cases that, because they don't shock the senses, never come to light in the court, but somebody has multiple felonies and I give them that little bit of a shot, and sometimes I'm rewarded and sometimes I'm not rewarded. In this case, I'm hoping I will continue to be rewarded by your not having any probation violations and continuing to do good work in our community. And hopefully you can put all this behind you. Sadly though, I will say, I'm sure to the people that you hurt to begin with that's probably sadly not going to happen. And that's why I believe you probably will carry this around for the rest of your life. Defendant having tendered plea of guilty, been found guilty by this court, misdemeanor theft, 2913-02A3 and B2, misdemeanor of the first degree. suspended. Will also note, I'm sorry, I wanted to make this point, that I think the first, not just my words that I made, but the fact that I did not step you down. That sentence I gave you, you did every day of it, because I thought that was important. So I wanted to say that as well. Imposition of the incarceration portion of this sentence is suspended. Your order placed on probation for a period not to exceed 1 year on the condition there be compliance with the rules and regulations of the Lucas County Adult Probation Department, with the added conditions that during this time you abide by all the laws of this state and this nation. You don't leave the state of Ohio without permission of the PO or in the alternative, the court. Any further recommendations any recommendations that your PO has, you continue to abide by them. Everything you're doing now. Court has considered defendant's present and future ability to pay. Considering all factors pursuant to 2941.5(d), I do find defendant has or may be expected to have the means to pay the cost of supervision, confinement, prosecution. That's authorized by 2947.23, 2929.18, 2951.021,